Yes.
My Lords, purpose. On to purpose. In my submission, there are two relevant purposes for the construction of the provisions in question. The first, and I'll make these good by taking to the recitals of the 2013 regulation. The first is to apply, in line with the need to harmonise, streamline and simplify the legislation, apply the same meaning for the term designation across all agricultural sectors and in respect of all of the marketing standards, rather than having the individual definition of designation that previously applied in the context of milk only. So let me show you where I get that as a matter of purpose. If we turn up the regulation at page 468, that's where we need the recitals, behind tab 32 for those with a hard copy bundle. And this is from the base of recital 1 on the left-hand side and going over to the top of the right-hand side. We're talking about the reform that is embodied by the 2013 regulation. The reform should also, as far as possible, harmonise, streamline and simplify the provisions, particularly those covering more than one agricultural sector. And that's to put this in context. Under the previous regulation, there were a melange of different articles.
Sorry, which recital was that?
Recital 1.
Recital 1.
Recital 1.
Yes, it's the last three lines of the left-hand column.
And the first one of the one on the
yes.
right. And under the previous regulation, there were, for example, different articles addressing the dairy sector, spreadable fats, meat, so on and so forth. And all of these were brought under one article, Article 78, for the purposes of the 2013 regulation. So we see that's purpose 1. It's to unify the meaning and also, in order to streamline, to avoid duplication or overlapping meanings. So we say there's a narrowing and a clarificatory approach to the use of language. We say that is satisfied by my constructions and not those of my learned friend. The second purpose is to give effect to the so again looking at the meaning of designation and the provisions. The second is to give effect to the underlying aims of the regulation in defining marketing standards under Article 78. And these we see from recitals, principally recitals, starting at 64. So on page 469, left-hand side, 2 up from the bottom, 64. The application of standards for the marketing of agricultural products can contribute to improving the economic conditions for the production, marketing and quality of such products. So it's maintaining quality. But it's not just about that. It's also, at 65, it's appropriate to maintain marketing standards by sectors or products in order to take into account the expectations of consumers and to contribute to the improvement of the economic conditions for the production and marketing. So again, in that, and at 70, there's a reference at the start, in order to take account of the expectations of consumers and to improve the economic conditions for the production and marketing, and so on and so forth. And then at the base of this recital at 70, there's a reference which I rely on in particular to the need to avoid confusion. Moreover, this is 6 lines or so up from the bottom, moreover, the marketing standards should take into account the possible risk of consumers being misled as a result of their expectations and perceptions. So the standards are to maintain quality, to standardize, as one might imagine, and to make sure that consumers are not misled. But it's not limited to that. This is a point that also comes across. It's also important to regulate the conditions of competition between different sectors. So this is not just the dairy sector and the non-dairy sector, it's also between the various different agricultural sectors and their competitors. And you see that in particular at recital 76 on page 470. So we see for certain sectors and products, those are the ones with which we're concerned, definitions, designations and sales descriptions, so those are the 3 terms that come out in Article 78, are important elements for determining the conditions of competition. Therefore, it is appropriate to lay down definitions, designations and sales descriptions, again, the trinity of different terms, for those sectors and/or products which should only be used in the Union for the marketing of products which comply with the corresponding requirements. So we say this is defining these three terms. Definitions, designations, and sale descriptions are going to be set out for the relevant sectors, and only compliant uses of those three will be allowed within the Union for marketing. So it's beyond mere application of names to products. It's throughout the whole gamut of marketing for those. So we say that's another important point. It's not just consumer protection and consumer standards. It's also to regulate the use of these terms in marketing and to allow fair competition between parties such as my client and my learned friends. Now, that purpose, those two purposes, if I can put it that way, are considered further or addressed further in Tofu Town, as is often the case when the CJU consider legislation. And so if we can turn up Tofu Town now, I'm going to attempt to deal with everything that arises in Tofu Town at one go as we go through. So there'll be things that go a little bit out of line. But tab 70 of the bundle, 1062 is the starting page, and then 1063 is the first point I would refer your lordships to. So under paragraph 3, when they're addressing the legal context, express reference there to Articles 64 and 76, which are the two I referred you to. There isn't an express reference to Article 70, which is the one about needing to avoid consumers being misled. But as you'll see in the body...
Recital.
Recital, I beg your pardon, my lord, I've done it again, misspoken. So recital 64 and 76, ones they call out, they don't refer specifically to recital 70, but they do consider the need to avoid confusion and people being misled in the body. So...
just as a matter of interest,
yes, my lord.
It may be that you can't answer this. Are the recitals in much the same form under the previous regulations?
Well, my lord, yes and no is always the answer. Well, no, but yes and no in a relevant way, I hope. My learned friend took your lordships to the earlier recitals, and I think the reason why he took you to the earlier the recitals of the earlier regulation is because he was looking for things that specifically mentioned milk and dairy products. So there are recitals under the 2007 regulation that refer to the importance of similar sort of aims in relation to dairy products. There are no dairy-specific recitals in the 2013 regulation because the 2013 regulation brings together all market sectors, and so it would be verboten to refer to dairy-specific matters. And so within that, and similarly in the 2007, there is no reference to streamlining because they certainly weren't streamlining in the 2007 regulation because they have all these different articles. So that's the only answer I can give on that point. The next paragraph, the CJU go through the relevant provisions, as they often do. The next paragraph that my learned friend particularly relies on is at paragraph 9, and I'll just address that now. So this is the passage where the CJU say the provisions of Annex 7, Part 3 to Regulation 1308 reproduce without making substantive changes the provisions which were set out previously in Annex 12 to the 2007 and indeed the earlier ones. Now, my learned friend relies on that particularly to say that there's no substantive change. So this is absolutely accurate in what it says, as one would hope, but the provisions which it's referring to, the reference is only to Annex 7, Part 3, so it's not referring to the earlier parts of Annex 7, which is where the change in definition of, where the definition of sales description comes in. And so it's not referring to that point, which is a significant change, and this is a point that the Court of Appeal addressed. It's perfectly accurate to say that Part 3 of Annex 7 reproduces without making substantive changes those provisions previously in Annex 12, but they do so. The bits that are reproduced don't include the definition of designation. And indeed, as we will see when I go to my learned friend's helpful comparator chart, there are changes made to the 2013 regulations wording, which expressly take into account the change in the removal of the definition of designation. And so it's absolutely right to say there's no substantive change, but there's no substantive change as a result of the tweaks that have been made to take into account the change in definition of designation. So that paragraph doesn't get my learned friend where he wants to. Paragraph 15 is where I'd go next on the following page, 1066, auspicious date. Paragraph 15. So the VSW is a German association whose responsibilities include combating unfair competition. Tofu Town is a company which produces and distributes vegetarian and vegan foodstuffs. And this is important, the point I rely on. It promotes and distributes, among others, pure plant-based products under the designations. So this is everything that follows this is a designation for the purpose of the regulation. Soya 2 tofu butter, plant cheese, veggie cheese, cream, and other designations. So from that, and again, this is a point the Court of Appeal picked up on, Soya 2 tofu butter is a designation. So my learned friend's submission that a designation excludes trademarks and is only the generic name of a product or solely a descriptive term is inconsistent with the identification of Soya 2 tofu butter, which has a brand name, and then tofu butter, as a designation at large. And it's consistent with my interpretation of designation, which is a broad term to do with indicating something to do with a product, which includes names, generic names, brand names, but it is inconsistent with all of the constructions put forward by my learned friend. Because, just to be clear, Soya 2 tofu butter cannot be solely a descriptive term because it has Soya 2 at the front, and it cannot be a generic term, and it cannot be the name used at all stages of marketing in the sense that my learned friend means, which is a sort of generic name. So,
sorry, why can't it be a name?
It could be a brand name. The name, as my learned friend uses it, which is the name of a used at all stages of marketing, which is a truly generic descriptive name, excluding trademarks. It cannot be because there is a trademark within it. There's a danger, not a danger, there's a difficulty within this case in particular that arises from the fact that the term designation as I construe it is broader than others. So things may well be designations both on my learned friend's construction and on mine, but they may be designations on mine and not on his. And the use of names and indications and words like that is somewhat loose within some of the authorities, both within the CJU authority, but also when we get to look at ALPRO, things really do seem a little bit confused on occasion. None of this detracts from the fundamental point on my case, which is that it all turns on what use for means, really. Designation is not the heart of it. So, paragraph 17, it's important to see, before I go, looking at those designations, Soya 2 tofu butter, plant cheese, veggie cheese, cream, none of those, even arguably in my submission, fall within the second limb of the proviso, being clearly descriptive, factors which use the term to describe a characteristic. Because veggie cheese is cheese, putting veggie in front of it, you're not using the designation to describe a characteristic. It's not like non-milk, where that's going in there. So those are not, in my submission, these are not terms that would fall within the proviso, and they were not argued before the CJEU to fall within the proviso. That's not so my learned friend's right about one aspect of this case not being helpful is that it wasn't the CJU considering the scope of the proviso, or indeed directly considering the meaning of designation within point 5. And you can see that from the recordal of Tofu Town's submissions at 17. Tofu Town maintains, to the contrary, so it was held that these were are not acceptable these are prohibited in Germany. Tofu Town maintains, to the contrary, that its advertising of plant-based products with the designations at issue does not infringe those provisions of EU law, since the way in which consumers understand those designations has changed massively in recent years, and it does not use terms such as butter or cream in isolation, but always in association with words referring to the plant-based origin. For example, tofu butter, rice spray cream. So what was argued was people's perceptions have changed, not that these are descriptive uses that would fall within the proviso. And the National Court then referred questions, which again, you see under 19, which again are not to do with the scope of the proviso. They're all to do with whether the designations in question are somehow saved from objectionability because of the descriptive additions. So, question 1, can Article 78.2 of the regulation be interpreted as meaning the definitions, designations and sales descriptions set out in Annex 7 need not satisfy the relevant requirements of this annex if the relevant definitions, designations and sales descriptions are expanded upon by clarifying or descriptive additions, such as
Sorry, what paragraph are you reading?
So I'm under paragraph 19,
Yeah, question 1.
question 1.
Yes, thank you.
So what was being asked, just to give you the context of what the CJU were grappling with, was not what's the scope of the proviso. It was, is this somehow, because of the change in view of and understanding of consumers, is there a pass, is there some way that the use of these terms is out with the scope of Article 78.2? Not that it's saved by something within the proviso. You see that because it's, and similarly the questions there's to do with composite matters and other things. And then at 20 we have the CJU doing what it again often does, which is to say this is the question we're going to answer. 20, by its 3 questions, which it's appropriate to examine together, the referring court asks essentially whether Article 78.2 and Annex 7, Part 3 to the regulation must be interpreted as meaning they preclude the use of the term milk and designations that the regulation reserves exclusively for milk products being used to designate, doesn't say what that means, a purely plant-based product in marketing or advertising, even if those terms are expanded upon by clarifying or descriptive terms indicating the plant-based origin of the products concerned. So, just pausing there, in my submission, the question as reformulated really doesn't make sense if the regulation, if the use of, if the control over the use of designations, terms such as milk, is limited to the use of the word on its own. So one of my points is that within Article 78.2 and Annex 7, Part 3, when use of a designation is controlled in some way, it's not the designation on its own, it includes the designation within a composite phrase, such as post-milk generation, or non-milk, or milk-free. And that question that's being asked really doesn't make sense if designation was limited only, the designation within Part 3 of the regulation was being limited to consideration of the designation on its own rather than broader senses. My Lord, do you look, have I just garbled that?
Well, the question might involve asking that very question, what designation means, in the way that the court has rephrased the question.
Well,
but, I mean,
my Lord,
I don't think at the stage when they're simply rephrasing the question, they're not making any assumptions about what any of it means. Are they just opening the curtain to see how the play is going to develop?
My Lord, they are, but it has to be something that's within the scope of the play. It has to be in the script and not an entirely different genre, we would say. And if designation could only refer, or the control of uses of designation could only refer to the use of the term itself, and you couldn't take into account any surrounding words, which is my submission on use 4 in point 3 is that it includes use of the designation with surrounding words. It must do so. If that's not the case, the question makes no sense, is what I would say. because it's plainly predicated on the possibility of using clarifying or descriptive terms. So, there's also no suggestion in the, just looking at the reformulation of the question, again, there's no suggestion that they are considering the terms within the proviso, the requirement within the proviso of something to clearly describe the characteristics of a product. It's just not on their radar. And that's something that I say is important when we come to see their consideration of the Commission decision, because it's not, they address it all from the point of view of listed products rather than whether the second limb of the proviso applies. So, the Court then addresses the question as reformulated in paragraph 20, and skipping on to paragraph 32, they have, if I can summarize it in general terms, by the time they get to 32, they've concluded that the use of the terms in issue, the designations, are not permitted under either points 1, 2, or 3. Okay? So the use of the particular designations don't fall within the permitted uses under 1, 2, or 3, and so they then consider, under paragraph 33, 3.5, and the proviso. So, at 33, furthermore, although according to Annex 7, Part 3.5, first sub-paragraph, to Regulation 1308/2013, the names, and my learned friend relies on these saying names rather than designations, but in fact, the way in which I don't think anything turns particularly on that precise use of language at this stage. There is a significant list of names within 2013. In fact, they're referred to as names when you get to point 2. So those names cannot be used for any other products than those which are set out therein. The second subparagraph of point 5 provides that the first subparagraph does not apply to the designation of products, the exact nature of which is clear from traditional usage, and or when the designations are clearly used to describe the characteristic quality of the product. They then move on to consider at 34 the list of products that are listed by traditional usage. So 34 concerns the first limb of the proviso. They're not considering the second limb at all. And at 35, they say, in the present case, it must be observed the list does not contain any reference to soya or tofu, so none of the products are on the list. And then at 40, the Court goes on to say, it follows from all the foregoing that the term milk and the designations reserved exclusively for milk products cannot be lawfully used to designate, so that's the term used in the first limb of the proviso, to designate a purely plant-based product unless that product appears on the list in Annex 1 to Decision 2010-791. Then it goes on to say the addition of descriptions or explanations indicating the plant origin of the product in issue, such as those at issue in the main proceedings, does not affect such a prohibition. So again, they're thinking about the first limb, not the second, we say. And then at 41, furthermore, it's clear from reading an Article 78.2 and Annex 7, Part 3.6, first subparagraph, that the prohibition applies equally to marketing and publicity. So they're drawing, it's not just about applying the name on a sticker to the product, it's broader, it relates to marketing and publicity.
Can I just go back to 34?
My Lord, yes.
They seem to be treating the proviso as effectively a single proviso,
Well,
albeit it's got an and or in the middle of it. Because when they talk about, therefore the only products set out in that annex fall within the exception laid down in the second subparagraph.
my Lord,
And
yes.
they've previously defined the second subparagraph, I think, as the whole of the proviso, haven't they, in 33?
My Lord, yes. And to be absolutely clear, this is the point that Lord Justice Arnold focused in on the Court of Appeal. And before him, I didn't want to. I indicated pretty clearly that I was of the view that actually the proviso, the second limb was not exclude. You weren't excluded from the second limb if you weren't on the list. But it wasn't a point I was sticking to my guns on. That's why you have the Obiter decision of Lord Justice Arnold.
Yes.
And so it's focusing on that. In my submission...
I'm just simply picking you up on you're saying that here is the CJEU only talking about the first limb. I mean, in fact, they're talking about the whole proviso, so it's a single proviso.
It is a single proviso, but the words they're using in terms of something designating rather than...
Yes, sure.
is the first limb part of it. But, my Lord, yes. Sorry.
But you're accepting, as I understand it, that the proviso has two parts to it,
Yes.
and that therefore you're accepting the position taken by Lord Justice Snowden.
My Lord, yes.
But it looks as if this reasoning of the CJEU rather contradicts that, does it not?
Well, that's the reason.
Because they're coming to an ultimate conclusion about the application of point 5, including the proviso, to the facts of the case.
My Lord, they are, but they're doing so looking at it, in my submission, looking at it through the lens of our products on the list, and without, in their reasoning or anywhere flagged up, considering or engaging with the question as to whether or not these terms are clear, the designations, plant cheese, veggie cheese, cream, soya 2 tofu butter, are used to clearly designate a characteristic of the product.
Right.
So in my submission, because that's why I took it to show you what the questions were and how the focus was, is it's taken at its face. I can well see how Lord Justice Arnold formed the view that this all fell within it, and it's why I didn't dig in and say, look, it's plainly to the contrary. But there is a way of reading it, which is in fact the way adopted by Lord Justice Snowden, which is to say they were thinking about the first limb of the proviso, and at that point you can then see the distinction between the first limb and the second limb. The first limb is to do with products, and it makes sense that you list products on a list, whereas a broad case-by-case analysis of whether a use is descriptive is something that's not amenable to be listed. Many of the ways you can describe a product fairly and descriptively, it would be peculiar indeed if you had to say there was a traditional use of non-milk for non-milk things, or milk-free, or whatever. It's a different class of consideration, but I fully accept that the way in which the CJU express themselves is open to the interpretation that Lord Justice Arnold adopted. That's why there was such a debate between the panel in the court below.
Thank you.
There was no argument that veggie cheese was a designation clearly used to describe a characteristic quality of the product.
There was none, and in my submission, my Lord, that's entirely understandable. Veggie cheese does not, unless you already know, unless you've educated the public that veggie cheese doesn't just mean cheese, it can also be something you do with, I don't know, a veggie. You can make your tofu based, and then that's not a descriptive use of the term. So it's different in quality to a non-milk, milk-free type use of a descriptive in a negative sense, in a positive sense. These are a different class, and that's why I say that it couldn't really be argued that soya 2 tofu butter, plant cheese, veggie cheese, cream, veggie cream, I suppose that must have been cream on its own, it's just cream, could mean anything different. They don't, on their face, appear to be descriptive to me, and they weren't argued as such by Tofu Town in the before the CJU or the German court, as I see it. So that's why I say that the CJU were not really considering the escape hatch of the second limb of the proviso. Otherwise, if not faced with that paragraph, in terms of this, the paragraph within Tofu Town, which suggests that things must be on the list and it applies to all of the proviso. If not faced with that, then the logical reading of a list, the need to prepare a list that deals with traditional products as opposed to characteristics that are described, entirely favours the approach my learned friend adopted and was put forward by Lord Justice Snowden. So that's the stumbling block is what the CJU said, and I think it can be explained because they just hadn't turned their mind to this particular point. I find myself in the slightly peculiar position of arguing firmly for my learned friend's appeal when he hasn't addressed you on the point, and I certainly don't want to cut across his submission.
But you say that terms like veggie cheese, veggie cream, tofu, butter are different from milk-free or no milk in our situation.
Yes.
So what would the equivalent be? Sort of plant-based milk? Is that? I mean, what's the equivalent?
No, it's or in my submission, to say plant-based milk, that doesn't use the designation to describe anything, because what you're doing is you are describing something else using the designation. So if I'm saying non-milk about a product, I use the designation milk with a negative to describe a characteristic of the product. What I'm not doing, if I say veggie milk, which I don't think anyone ever says, but let's say veggie milk.
Yeah.
I say veggie milk, I'm not using milk to describe the product, I'm using veggie to describe the product, so I'm not permitted to use the designation in that way. That's my analysis, my lord.
Right. So you would say plant-based milk is problematic?
Yes, most certainly. Most certainly. It's common ground between the learner friend and myself that milk-free is fine, non-milk is fine. Where we part company is we would say oat milk, absolutely not. Plant-based milk, absolutely not.
Thank you.
So,
So just
sorry, my
go
lord.
off that ground again. How is a veggie not a characteristic of the product?
Veggie describes a characteristic of the product, but cheese doesn't. Veggie is describing a characteristic of the designation, whereas you're meant to use the designation to clearly describe a characteristic of the product. That's where I get. I've scratched my head a bit about it. I can't say it's a perfect answer, but it in my submission, it holds together. So, then, I was going through dealing with all the points. I'd looked at 41. Paragraph 43 then addresses, so this is the point I first came to this because I was talking about purpose. 43 addresses the purpose of this. So 43, as is clear from recitals 64 and 76 of the regulation, the objectives pursued by the provisions at issue consist in particular in improving the economic conditions for the production and marketing, as well as the quality of such products. The application of such standards is therefore in the interest of producers, traders and consumers, to protect consumers and to maintain conditions for allowing competition. These provisions, insofar as they provide that only the products that comply with the requirements they lay down can be designated by the term milk, and the designations reserved exclusively for milk products, even if those designations are expanded upon by explanations or descriptions such as those at issue in the main proceedings, contribute to the attainment of those objectives. And so, and then at 44, in absence of such limits, those designations would not enable products with the particular characteristics related to the natural composition of animal milk to be identified with certainty, which would be contrary to the protection of consumers because of the likelihood of confusion which would be created. That would also be contrary to the objective of improving the economic conditions for the production, marketing, and quality of milk and milk products. So the purpose is there need to be clear rules about the use of these designations in order to allow clear terms to be used to define terms of competition and to protect consumers. And there is nothing within that purpose that requires my learned friend's construction of designation or of use to say this only relates to use of generic terms, brand names are excluded, so on and so forth. So we say, given the aims that are set out there, there is no reason, and this is on my learned friend's construction of designation, no reason why only generic names, rather than brand names, or any other way of referring to or identifying products, should be considered to be designations. There's no purpose to limiting it in that way. And in particular, the exclusion of brand names, which would be contrary to the recognition of soya 2 tofu, soya 2 tofu butter as a designation, but the exclusion of brand names would be very strange indeed, given the fact that prohibition applies to marketing and publicity as well as to sales. Now, the Court of Appeal addressed this particular point in terms of limiting to exclude brand names at paragraph 46 and onwards, and it's worth just looking at it. So this is behind tab 10, page 137 of the bundle. So at 46, 137, we see Lord Justice Arnold's decision. This is referring to the use of soya 2 tofu butter and making clear that soya 2 is a brand name and a registered mark. This was in the context when my learned friend was running the case that a trademark was excluded from a designation, so the sort of trademark escape. He's not saying that anymore. But then at 47, Lord Justice Arnold identifies a number of arguments that were canvassed below, and it's just worth looking at them. Fourthly, and following on from the third point, having regard to the purpose of Article 78 and Annex 7, Part 3, identified by the court in Tofu Town, it would be surprising if the term designation did not include a trademark or part of a trademark. A number of examples were discussed in argument. Suffices to consider three of them. The first is Oatly milk. Counsel for Oatly argued that this phrase could not be validly registered as a trademark for oat-based products since it would be deceptive, whereas the trademark had been found not to be deceptive. I'm not sure whether that gets anyone anywhere. The interpretation of designation in Article 78.2 and Annex 7, Part 3 cannot depend on whether the trademark could be validly registered, however. As counsel for Oatly accepted, on Oatly's interpretation, designation would exclude an unregistered trademark. Thus, it would exclude Oatly milk, by TM he means unregistered mark, even assuming that Oatly milk was unregisterable. So this is the point I was making earlier, my lords, which is that if a designation has to exclude brand names, if it has to be solely the generic term for a product or the generic name used at all marketing, then one could circumvent, take milk, the restriction on using milk for non-milk products just by plonking Oatly in front of it. And that's just not a sensible reading as it goes on. Then the second example is, I can't believe it's not butter. That's a mark that's registered. Lord Justice Arnold says, without prejudging the question of whether the use of this phrase is prohibited by 78.2 and Annex 7, Part 3, it's difficult to see why that question should be preempted by the fact it's registered and or used as a trademark. Now, just to be clear, it is certainly arguable that I can't believe it's not butter. Within that you have it's not butter. That might well fall within the equivalent of the proviso for spreadable fats. It's not a milk point, it's a spreadable fat point. But again, that does not, it doesn't help, it doesn't support my learned friend's contention that trademarks or brand names should somehow be excluded. And then the final point of 49, I don't think I need to go to, that's about Jersey milk as a collective mark. So, in my submission, there's no justification in the purpose of the legislation as addressed by Tofu Town or as explained by the Court of Appeal, or indeed as I've shown you in the recitals, for the limitation of the term designation to mean only the generic name of a product or to exclude the brand name from the meaning of that term. Which brings me on to, having looked at purpose and Tofu Town and everything in Tofu Town I needed, to move on to the actual context of the words within the regulation itself. Now I need to start by looking at this within the regulation itself, but I'm going to come on to my learned friend's useful comparative ready reckoner in a bit. But first of all, at Article 78 in the 2013 regulation, page 471. So this is the unifying factor where, rather than being limited to milk or spreadable fats or meat, everything is addressed in one go, Article 78. So these different sectors. We have the heading, definitions, designations, and sales descriptions, echoing what was said in the recital, three terms which in my submission must have three separate, three different meanings. It's possible for them to overlap or one to envelop the other, but it would be wrong to construe as, in my submission, as the consequence of my learned friend's case, designation and sales description to mean the same thing. So we see, my learned friend's shown you this, there's a list of products, including milk products, and then at 2, the definitions and designations or sales descriptions provided for in Annex 7 may be used in the Union only for the marketing of a product which conforms to the corresponding requirements down in that annex. Again, it concerns, as they observed in Tofutan, it concerns the marketing of a product, not just the sale. Then if we turn to Annex 7, which is at 475, we have the heading that we've seen, definitions, designations, and sales descriptions of products referred to in Article 78. For the purposes of this annex, so that's the whole annex, with all different parts, the sales description means the name under which a foodstuff is sold within the meaning of Article 5.1 of that directive, or the name of the food within Article 17 of EU Regulation 1169/2011. Now, there's no definition of designation within that. When I said in Tofutan at paragraph 9, Tofutan was only referring to part 3 within this annex when it said that the 2013 regulation reproduces without substantive change Annex 12 of the 2007 regulation. So this bit is not one of the ones they were referring to. Sales description is defined for the whole of the annex, and in my submission, designation must also have a meaning that works consistently for all parts of the annex. And in my submission, looking just at the meat from bovine animals section, following on, it's immediately apparent that if my learned friend's construction is adopted, which is to say it's the name or a generic name, or the name used at all terms in marketing, as in the previous regulation, if that's adopted, then Part 1, meat of bovine animals, runs into difficulty. And let me show you that. So, at point 3, you see sales descriptions. And this defines, point 3, sorry, I beg your pardon, am I causing trouble? Sales descriptions are set out for the meat of bovine animals aged less than 12 months, and they must only be marketed under the following sales descriptions that are then set out, various forms of veal. And then under B, 8 months to 12 months. And then on page 477, what's said is the sales descriptions, referred to in paragraph 1, may be supplemented by an indication of the name or designation of the pieces of meat or offal concerned. Now, if sales description means name, it's difficult to see what that is adding. If we read it as sales description, if we read designation as meaning the same as what is now sales description, you'd have the sales description referred to in paragraph 1 may be supplemented by an indication of the name or sales description of the pieces of meat. So that's if designation is having the meaning ascribed to sales description. Or if it means only the generic name, then again, if designation means the generic name, the sales description referred to in paragraph 1 may be supplemented by an indication of the name or the generic name of the pieces of meat or offal concerned. So My lords, in my submission, designation must be broader than sales description and broader than just the name if that paragraph is to make sense. Otherwise, you're just saying the name can be supplemented by the name or the name. So,
isn't it just saying that if, for example, you use the word veal, you can supplement it by saying it's a veal kidney rather than a veal steak?
well, my lord, you can...
Pieces of meat or offal concerned. It's not saying anything more subtle than that, is it?
Well, my lord, it is, but it's sorry, it's not saying anything more subtle, but it's saying that you can use the importance is that it's supplemented by an indication of the name or designation of the pieces of meat. It's broader. It's not limited to just for name and designation to have the same meaning. My learned friend says designation means generic name. It would make no sense to have, you can supplement it by the name and the name. Remember, my lords, our construction of designation includes the constructions contended for by my learned friend. We say it's a broad term, and that's why it's only when you try to apply the precise terminology my learned friend seeks to ascribe to it that trouble happens. And then,
but I mean, taking up Lord Briggs's point in 2, if you were to say it was the sales description was beef, you then describe the part of the body of the carcass that the beef comes from, and whether you call it the name of the part of the body or the designation of the part of the body makes no difference.
well,
I mean, if it's a ribeye or a sirloin or whatever.
my lord, precisely, because we say that it's with a leg, a shank, or whatever. These are not. That's designation being used in a broad sense that is not just the generic name for X or Y or the name under which it's sold at all times of marketing. It allows for accurate, clarificatory indications, designations to be used. This, I rely on this saying, if you apply the terminology, apply the construction my learned friend contends for, you find yourself using duplicative terminology within this paragraph. If it means generic name.
Sometimes a draftsman does. He thinks the two words mean the same thing, but since other people may not, he's going to say, well, say it, name or designation.
Well, my lord, that may be so. I work with I'm looking for inconsistencies because that's what I'm aiming for. And so, Your Lordship, if the answer to it is, well, they just took their eye off the ball or they thought this was for emphasis, then that's an approach. But in my submission, it's telling that these issues arise on my learned friend's construction, but not on the broader natural meaning of designation for which
as I understand it, what you're saying is that the sales description, which means the name under which a foodstuff is sold, may be supplemented by an indication of the name of the pieces of meat or offal concerned. So that is the pieces of meat. You can supplement the name under which it's sold with the name of the pieces of meat concerned. And you then say, well, they also have the word designation, and there has to be some meaning given to designation apart from name.
My lord, yes, otherwise it's duplicative. I'd say no more than that, and I don't mean to be beastly to the draftsman here and suggest they're wrong, but it's just trying to find a consistent meaning. So, turning to the part concerning milk, I'm going to do this from my learned friend's Ready Reckoner, which is at page 55.
55?
It's where he sets out the relevant provisions. In an annex to his.
Yeah.
My lord, you asked my learned friend about the coloration. I think there may be an issue within this in that sometimes if blue has overlapped yellow, it looks green when what it's meant to be is blue. So I say that in a spirit of assistance to my learned friend in terms of some of the coloration. let me just get this right here. Milk is at part 3. We see on page 52, we're dealing with the recitals. Article 78 is at 53, and then the annex comes in at 54. And so the definition of milk is in part 1. So we see that on page 54 under part 3, milk and milk products. Milk means the exclusive. So I couldn't see why that would be green, but I'm assuming it's blue on top of yellow.
Well, it's a difference between shall mean and mean, I suspect.
Yeah.
Yes. Though means is the same. It's the same. My lord, you're ahead of me. Right. Then under 1b, so the term milk. So milk means this, but the term milk may be used in association with a word or words to designate the type, grade, origin, and or intended use of such milk. Now, if designate is what's being used as a verb there, or what's being done as a result of it is you're using a designation, that means that an indication of the type, grade, origin, or intended use which would be a designation because you're designating it, that's not the brand name, it's not the generic name of a product. It goes beyond my learned friend's limited use of designate as being the name of the product. And then there's an important point on page 55, looking at the central column and the far right column. The following shall be reserved exclusively for milk products, they both say. And then at A, the following designations, and an A in relation to in the 2013 on the right, the following names used at all stages of marketing. Now, if designation meant the same as it did under the 2007 regulation, then there would be no need at all to change that word from designation to names used at all stages of marketing. So far from being a point in my learned friend's favour, we say this is how this annex, this part of Annex 7 was adjusted to keep a consistent meaning. And similarly, at the base of page 55, you see that next to B, designations or names within the meaning of Article 5, so on and so forth. And on the equivalent on page 56 is names. So not designations or names, but just names within the meaning of Article 5 of the directive. So that they've removed there the use of designation, which is consistent with the change in meaning of the term designation.
Sorry, could you give me that point again?
It's to do with B in
yes.
the 2007 and B in the 2013 regulations. B in the 2007 says
yes.
designations or names, and in 2013 only names, designations deleted.
Yeah, thank you.
So again, only consistent with designations changing in meaning. Now, there's. I'll come on to that. So I'll work my way all the way through here, and then I'll address your lordships on the point about how name is used in Article 17 of Regulation EU 1169/2011. Because in my submission, it's absolutely clear when one looks at that regulation in its broad sense that it means the name used at all points in marketing. It's not limited in the way my learned friend says when he contends there's a difference between sales description and his meaning of designation. But moving on, we see point 3 in the right-hand column. The term milk and designations used for milks may also be used in association with a word or words to designate composite products. So again, that's suggesting that a designation and the act of designation is not limited to the use of the term or designation as they're referring to on its own. You can add further words and it still constitutes use of a designation or a designation. An act of designation, which again is part of my contention when we come to point 5 as to whether use for has to be use of the designation on its own, or it can be within a composite mark such as post-milk generation. I say the latter. And then, so point 3 is about composite uses, so that's things like, you know, use for, say, a strawberry milkshake or something like that. And then at 5, the point that we're going to come back and address, the designations referred to in points 1, 2, and 3 may not be used for any product other than those referred to in that point. However, this provision shall not apply to the designation of products the exact nature of which is clear from traditional usage and or when the designations are clearly used to describe a characteristic property. So I'll address you on that shortly in terms of the broader construction points. And then 6, my learned friend relies on point 6 as saying this is the sweep up. It is a catch-all at the end, but an important part of point 6 is it catches, yes, deceptive matter, so the use of presentations which claim, imply, or suggest the product is a dairy product when it isn't, but most importantly, it has nothing, it's not limited to designations. It has nothing at all. It doesn't require the use of one of the controlled terms. So it's of a different class of prohibition to point 5, which is controlling how the terms controlled are to be deployed, how the designations are to be deployed. Point 6 is broader than that, and essentially is a sweep up saying, don't be deceptive. But what it doesn't do is advance the argument on construction in relation to Annex 5 at all, sorry, point 5 at all in my submission. So, legislative history. I agree with my learned friend that the legislative history is relevant and a useful tool for construction. My learned friend's contention that designation should have the same definition in the 2013 regulation as it did in the 2007, we say is wrong for 3 principal reasons. First, the definition that was in the 2007 regulation has been deleted and indeed has been replaced with another. So you have sales description coming in. And it's said by my learned friends, and we say it would make no sense at all to delete, having deleted the definition, ascribed what we say is essentially the same definition to a different term, sales description, to then say, well, designation must have the meaning it previously did. My learned friend seeks to meet that by saying, well, designation doesn't have the same meaning on his construction as sales description, because sales description is defined as, to get the words exactly right, sales description is defined as the name under which a foodstuff is sold, whereas designation, he says, means the name used at all stages of marketing. However, in my submission, when we look at the regulation referred to, which I'm just trying to do it from this one, the regulation referred to, so name of the food within the meaning of Article 17 of Regulation 1169/2011, it's abundantly clear that that is the name that must be used at all stages of marketing. And let me just make that good. So tab 53, page 671, is the relevant
What was the page number again, please?
Sorry, I beg your
The page number again, please.
Page number is 671.
Thank you.
So the regulation starts at 659, but the relevant provision is at 671. So we see the name of the food. The name of the food shall be its legal name. In the absence of the name of the food shall be the customary name, or if there's no customary name, customary name is not used, a descriptive name of the food. So it's a broad definition of name. In terms of how it must be used at all stages of marketing, one needs to go back to how the provision is, which is, and look at Articles 6, 8, and 9. So Article 6 of this regulation is at 668, and the heading is Basic Requirement. Any food intended for supply to the final consumer or to mass caterers shall be accompanied by food information. Okay, so you need food information. Food information is then addressed at under 9, Article 9, list of mandatory particulars. In accordance with Articles 10 to 35 and subject to the exceptions contained in this chapter, indication of the following particulars shall be mandatory. The name of the food. So again, that's how it needs to be used. Now, in terms of that being the name used at all stages of marketing, if one goes back to Article 8, responsibilities, we see Article 8.1, the food business operator responsible for the food shall be the operator under whose name or business name the food is marketed. And then 2, the food business operator responsible for the food information shall ensure the presence and accuracy of the food information in accordance with the applicable food information law. And then there are certain points as to how it's used. And then when we get to 6, food business operators within the business under their control shall ensure the information relating to non-pre-packed food intended for the final consumer for supply or mass caterers shall be transmitted to the food business operator receiving the food to enable, when required, the provision of mandatory food information to that final consumer. Mandatory food information including the name of the food. 7, in the following cases, food business operators within the businesses under their control shall ensure that the mandatory particulars required under Articles 9 and 10 shall appear on the pre-packaging or on a label attached thereto or on the commercial documents referring to the foods where it can be guaranteed that such documents either accompany the food to which they refer or were sent before or at the time as delivery. And then A, where pre-packed food is intended for final consumer but marketed at a stage prior to sale to the final consumer, and where sale to a mass caterer is not involved at that stage. And then B, where pre-packed food is intended for supply to mass caterers for preparation. So, and then notwithstanding the first subparagraph, food business operators shall ensure the particulars referred to in A, F, G, and H of Article 9.1, that includes the name, shall also appear on the external packaging in which the pre-packed food are presented for marketing. Names are to be used at all stages of marketing. This is not just at the point of sale. This is a general requirement that food, when it's intended for supply to a final consumer under Article 6, must be accompanied by the food information in accordance with this regulation. So it really is the distinction my learned friend seeks to draw between the sales description and use at all stages of marketing is entirely artificial in my submission. So I said there were 3 principal reasons why the history doesn't assist my learned friend. The second is those amendments that I showed your lordships, the amendments made to Part 3 of Annex 7 in the new regulation, the 2013 regulation, which reflect that change in definition of designation. So that was the change of, rather than in the start of point 1 or point 2, the reference to the following designations being reserved for milk, it was the following names used at all stages of marketing. The part, and then the separate one at 1B, the regulations within the part specific to milk have been adjusted in the 2013 regulation to take into account this change of definition. So that would not have been needed if my learned friend was right that designation meant what it always did. They could have just left designation there. They wouldn't have had to delete it. And then the final point, relied on by my learned friend in terms of legislative history, is the suggestion that there can be no substantive change to the effect of the 2013 regulation as compared to the 2007 regulation, because the CJU says there was no substantive change within that paragraph 9 of Tofu Tang. In my submission, paragraph 9 is entirely accurate. There is no substantive change. My learned friend's mark would have been equally prohibited under the 2007 regulation as it is under the 2013 regulation. So I agree with him that there's no substantive change. There's been a change to streamline in the definitions and of designation and sales description, but the consequence that he and I contend for are diametrically opposed. He says post-milk generation would have been fine under the 2007 regulation. In my submission, it would not, as I explained before. So, in my submission, the term designation, on its true construction, cannot be limited either to the generic name of the product or to exclude a brand name. It's a broad term with the meaning we contend for as set out at point 1A3 of the list of
So
issues.
could you take that a little bit more slowly, just so I record your conclusion? Thank you.
Yes,
the term designation, in true construction...
It's not limited either to the generic name of a product or to a description that excludes a brand name, that precludes the use of a brand name. It's a broad term which has the meaning as set out by the Court of Appeal and rehearsed at issue, read it, in the Statement of Facts and Issues. It extends to the use of words and phrases that refer to the product in any way, including as all or part of a trademark. So designation is a general indication of some quality or aspect of a product. That's what designation means, and it has a meaning that broad. And it's not limited in the way my learned friend contends. But, as I have said on a number of occasions, in particular to my Lord Briggs, the key point is really not the definition of designation, it's the meaning of use and use for within that point, part 3.5. I addressed you on this briefly before lunch. I'm going to do so briefly again just to make sure my submissions are there. So turning back to page 55 of the bundle where you can see the words that are used. So the first limb, the designations, so this is on page, 56, point 5. The designations referred to in points 1, 2, and 3 may not be used for any product other than those referred to in that point. In my submission, there are two issues that arise here. One is whether use, that prohibition on use is limited to use of the designation on its own, and so it can be escaped if there are surrounding words added, additional words. That's what my learned friend, as I understand it, contends by saying that post-milk generation is not use of the designation milk. In my submission, that's wrong. Use includes use as part of a broader mark, and that must be so, otherwise there wouldn't be the need for the clarificatory passage in the second limb of the proviso, which allows for use of designations to describe a characteristic quality of the product. But that can only happen if there's something extra going on, another word as part of the use of the designation. So that's the first point. And the second point, which is one I've discussed at somewhat more length, is what does for mean, use for? In my submission, it is not merely use to designate or as a designation on the limited construction my learned friend puts forward. Use for is use in relation to, it's used to indicate some sort of property of the product in question. So that's broader than use as a name. It encompasses descriptive use, but it is not, it's not any use at all, as my learned friend characterizes it. So on that point, in my submission, my construction of use in, that is use so as to indicate property is supported, insofar as one could tell anything, by the decision of the Dutch Supreme Court in Alpro. So let me take you to that. That's at tab 71 of the bundle behind, sorry, let me give you the page number. Page 1073 is where it starts. But the meat of it and the parts particularly referred to by my learned friend really start at 10. What's 1082 is the passage he was referring your lordships to this morning. First of all, in my submission, the way in which I don't criticize the certified translation as a translation at large, but the way in which the translation has been prepared means that it is very difficult indeed to form any view as to what is meant or what nuance there is between use of terms such as name, designation, indication, because these are essentially used interchangeably at various stages through this translation. And I can make that good by showing, for example, if one turns back to page 1080, the reference to Article 78 of Regulation 1308/2013, the title doesn't even use the term designation as translated. It's definitions, indications, and sales names for certain products, which is not a promising start. And then, in addition to the applicable marketing standards where applicable, the definitions, indications, and sales names. So they're using a different term already. Then at under 3.2.4 on page 1081, this is where the court sets out paragraph 48 of the preliminary ruling on tofu tang. And the passage cited at the base of that page, starting the fact that only for the products which comply with the requirements of Annex 7, if one compares that with the equivalent, paragraph 48 of tofu tang, there are differences which make it very difficult to see what it was the basis for the Dutch Supreme Court's decision. So the first line says, the fact that only for the products which comply with the requirements of Annex 7, Part 3 of Regulation so-and-so, is there the possibility of the name milk and the names reserved exclusively for dairy products being used in marketing or advertising. The equivalent sentence in the official translation is the fact that in marketing or advertising, this is on page 1071, the possibility to use the term milk, not name, and the designations reserved exclusively for milk products rather than the names reserved exclusively for milk products. So if one's considering whether a term should be designation or indication or name and what's meant by to indicate or designate, this is not a promising starting point. And matters go on. Going back to the translation of the Dutch decision, we see it has four lines down from that, the start of that paragraph. It says, gives the manufacturers of those products in particular the guarantee of undistorted conditions of competition and gives the consumers of those products the guarantee that the products indicated with these names meet the same quality standards. And what's said in 1071 is undistorted conditions for competition and to consumers of those products that the products designated by those designations. So it's it's confusing if one's looking at it to support what is meant by designation in a linguistic analysis. It's pretty much hopeless. But there is a
I thought you said our prose supported your case. Thus far, you're simply making a submission that it's completely incomprehensible.
Well, not so far incomprehensible, but what I'm saying is that when one looks at incomprehensible will do for me, insofar as anything can be drawn, it supports, is what I would say. But let's look at 3.2.6. My lord, if there's cake that I can have and eat you, I shall endeavour. 3.2.6 on page 1082. This is the paragraph my learned friend particularly relied on.
Yes.
So this is setting out, and your lordships observed that 3.2.6 appeared to support, and then they stepped back at 3.2.7.
Yeah.
Reminding you of what's said, 3.2.6, it also follows from the ruling of the case of Tofu Town, 3 above 3.2.4, so that's the bit that is garbled and hard to understand, that the first paragraph of point 3.5 concerns the use of a reserved name. Well, we'd say designation is what's in the actual paragraph in Tofu Town, to indicate the product concerned. In the context of point 3.5, amongst other things, and then they refer to the other paragraphs, the CJU refers to the names to indicate a purely plant product, as well as the products indicated with these names. So indicated, it could be designated, it's hard to tell. But having gone through all of that, the answer to the question they give at 327 is the answer to the question whether in a specific case there is use of a reserved dairy name to indicate a non-dairy product, as referred to in point 3.5, undeniably depends on the circumstances of the case. And my learned friend's point is that no matter how garbled this may be, this is suggesting that it's not just an automatic use of anything. It's not used within the prohibition, and I agree with that. But why I agree is that it must be use, we say, to indicate some characteristic. That's what use for is. There must be some informational transfer resulting from the use or pertaining to the use. Whereas my learned friend contends that use of the name to indicate must be use of the name as a name. And we say that goes far too far and is not supported. So although it would be it would be more helpful if we understood the workings of the Dutch court's decision, insofar as it just says that you don't automatically fall within point 5 of part 3 through any use at all, that's not something I cavil with. But in order for my learned friend to succeed on this appeal, he must establish that use for excludes anything other than use as the generic name or a generic descriptive. It excludes his use as a trademark, because that's what he's aiming at, his use of milk within post-milk generation, which is as a trademark. We say that cannot, on any basis, post-milk generation indicates something about the non-milk product to which it's applying. And at that stage, its use is prohibited unless it falls within the proviso. Which brings me on, drawing things together, to the application of what I say is the correct approach, the correct meaning of part 3, point 3 and part 5, point 5 and part 3, to my learned friend's mark in question. In the mark post-milk generation, milk is not use such as to clearly describe a characteristic of the product on any basis. Milk is used as part of the mark post-milk generation to refer to a non-milk product, but there is one, looking at it afresh, it's not a clear description of anything, and indeed my learned friend's contention that the mark is distinctive because if it were descriptive, it would be precluded from registration, cuts directly across his suggestion that post-milk generation just describes a characteristic quality of the product. So his suggestion that the mark is registrable because it's not descriptive, if it's not descriptive, how can it be describing a characteristic of the product, let alone clearly? But before we get on to that substantive point, in my submission, there's no proper basis for the court to revisit the decisions of the IPO hearing officer and the Court of Appeal on this point. And in my submission, my learned friend is wrong when he says that the judge in the first instance appeal decided anything in relation to the proviso. So let me just take you through the relevant points. Dealing first with the hearing officer, that's at core tab 13, page 165 is when it starts, but paragraph 21 is the key provision at page 176 of the bundle. So here, the hearing officer was considering the operation of point 5, and she held in terms that the mark does not clearly describe a characteristic quality of the goods.
Which paragraph, sorry?
21 on page
Oh,
176.
yes, yes.
So the exception, my italic, she italicizes the proviso. So she held not so. My learned friend relies on her findings that the mark is not deceptive. That's a different test. He's perfectly fair to point to it at page 180 when she's addressing how the average consumer would view the mark as an ironic way of saying its goods have moved on from conventional milk and are for consumers of a post-milk generation. But that is not the test, which is whether the use of the designation milk is in a way that clearly describes a characteristic of the goods. If anything, I say it's nothing clear, but if anything, it's describing a characteristic of the consumers. So it simply doesn't fall within the proviso. And there's no inconsistency between those two, because it's a different test, different burden of proof, different threshold, because one is a requirement that it be deceptive is what she was considering, rather than the mark having to, the use of the designation in question having to clearly describe something.
I mean, you're not saying this is some finding of fact from which we should be very reluctant to depart.
Well, no, it's...
Because we know what the mark is, and we know what, I think we know what the concept of characteristic quality of the goods is.
But in terms of grounds of appeal and where things have gone, we have this, which the hearing officer said. My learned friend then says that the judge at first instance addressed the point. The passage to which he referred you, where this was addressed, was the judge recording my learned friend's submission.
You're coming on to that, but I don't think you're saying this that paragraph 21 was a pure finding of fact, are you? Paragraph 21 of the hearing officer.
No, it's an application of the test that was advanced before her. It wasn't based on witness evidence or anything she assessed. So it's not.
I think that's all that Lord Briggs was
That's
asking.
what I was saying. I mean,
yes.
we're under a heading of your submissions is why should we or why can we depart from the decisions on this point of the courts below? The answer is if it's a pure point of law, we form our own view. If it's a pure question of fact, you're right, we exercise great caution. If it's something in between, well, it's more nuanced.
Well, my lord, we say it's between, but it is a matter of it is a matter of interpretation of what the mark says and means, and it's based on just the writing before you. So I can't say that you're not in as good a position to form that view as any of the ones below.
And should the view be based on the purpose, which is not to mislead the public? Is the view that of, do we have to imagine the view of the public?
My lord, I would say one has to view it through the lens of the notional average consumer, but there's nothing of the notional average consumer that is any different from you in this stage. So it's not requiring a great shifting of things, but anything in trademark law, Lord Briggs will understand me when I say this, is the test to which we return at all times, the view of the average consumer, and protection of consumers is really the reasonably circumspect and well observed.
Yeah, and the average consumer is a legal construct rather than somebody you discover from conducting a survey.
My lord, certainly. My lord, certainly. Their characteristics can be influenced by particular evidence of fact, but there's none of that in this case. I feel I'm expressing myself in a very complicated way when I could have just said yes at the start or no. But again, the judgment below of the on appeal. Just want to make good the point. Mr. Justice Richard Smith.
Yes, you were saying that a passage relied on was in fact a summary of submission.
It was a summary of his submission. So there were two paragraphs my learned friend particularly referred you to. One was at 29 and one was at 39. So 29 is at page 158 within the bundle. This falls within, in my submission, a recitation of what the appellant is doing. If we look at 26 at the top, regulation revisited 5 and 6. It says, I was taken to 5 and 6 of the regulation. And then he says, the appellant says the prohibition is directly directed. And then at 27, the appellant says, 28, the appellant also says. 29 in my submission, again, is just recording what the appellant said, because then you get to 30 over leaf at 159, which is when the respondent's argument is set out.
And it comes before discussion.
It comes before discussion. And then in discussion at 162, paragraph 39, no decision on the point. For what it's worth, no decision on the point.
And this is which paragraph, sorry?
Sorry, 39. So paragraph
39,
39 yes. is the absence of decision. Point 5 is not engaged, no question of the proviso arises.
Yes, quite.
And then the Court of Appeal, just to give the full picture, all three of them, they may have disagreed with each other when it came to a 2-1 in terms of the effect of the Commission decision, but each of them made clear that they considered their decision on the Commission decision was not necessary because they were of the view that the mark did not clearly describe a characteristic of the goods. And I can show you that within the Court of Appeal judgment. So that is paragraph 56 on page 140. My lord, you beat me to it. So this is having gone through reasons why this didn't apply. The third and decisive problem is, in my judgment, the trademark does not clearly describe a characteristic quality of the goods in question. I agree with the hearing officer that it would be understood as referring to potential consumers of the goods. It may be understood as alluding to the fact that goods are non-dairy products, but it does not clearly describe any such characteristic. Counsel for Dairy UK submitted there's no inconsistency between the hearing officer's finding the trademark is not deceptive and my conclusion that it does not clearly describe any characteristics of the good, any more than there would be in the case of a meaningless trademark. Furthermore, as Counsel for Oatly accepted, the instance of the burden of proof is different. The burden lay on Dairy UK to prove trademark is deceptive, whereas the burden lies on Oatly to prove it clearly describes a characteristic quality of the goods. This isn't a burden point, my lords. I mean, it's a distinction between the two, but it doesn't turn on the burden. Lord Justice Snowden, at page 144, he actually says early on that he agrees with this, but then at page 77, having said all that, so having gone through his learned analysis of the Commission point, he says, having said all that, I entirely agree with the critical point made by Lord Justice Arnold at paragraph 56, that if Oatly was entitled to argue the trademark fell within the second limit of the exception in point 5, its argument would nevertheless fail on the facts. That is because the trademark post-milk generation does not describe clearly at all a characteristic quality of any of the products in classes 29, 30 and 32 in relation to which Oatly wishes to use it, Rather, as obviously implied by the use of the words post and generation, the trademark describes the age-related characteristic of a particular cohort of people which Oatly intends should buy or consume its product. Could be age-related. The point is, my lords, the mark does not clearly say anything in my submission. If generation is used in the sense of descendants, then it's post-milk generation. It could be generation could mean something that happens after milk has been produced. It is not a clear description, even I would say, of its consumers, and even if it were a clear description of its consumers, it is not use of the designation to clearly describe a characteristic of the goods.
But isn't it effectively saying the same as no milk?
Yeah.
When you say it doesn't clearly describe that, it's telling people that this is a drink or some other food that has got no milk in it.
My lord, in my
Isn't
submission,
it?
no. It's not. It's not doing that clearly.
It's a food for people who have got over wanting milk. Post-milk generation. So it's food for a generation of people who don't want milk. Isn't it?
And therefore, there's no
And
milk.
therefore, if it's attached to a drink or a piece of food, it's saying there ain't no milk in this drink or food. And that's the point my lord's trying to make, isn't it? The fact that it goes around the houses to do that by talking about a group of people, a generation, rather than directly talking about the food, may not mean that it's unclear.
Well, my lord...
Sorry about the double negative, but I think you could...
No, my lord, I understand the point. My lord, in my submission, it is far from clear. That it might be said, the very fact that such wonderful legal minds and me and my learned friend are here arguing about it, this is not a clear description of a characteristic of a product. Post-milk generation, it may be possible to understand it in the way my learned friend suggests, but what is required, the purpose of this provision, is to make clear to consumers the particular nature of a product without room for doubt, and that's the limitation that's applied. My learned friend has decided, he says, in a way that is not such as to render it descriptive, so it's not a descriptive mark, so it must be something else. It's elusive, he says. Alluding to the nature of a product is not clearly describing the characteristic of a product.
Yes, I mean, you stand on what Lord Justice Arnold said at paragraph 56, essentially.
My Lord, yes, and I pray and aid Lord Justice Snowden's analysis, and indeed Lord Justice Jeremy Baker, who
Yes,
also...
I mean, one can deduce from it, or you can infer from it, that the product might be non-milk, but you say that that is not the clear descriptor that the second limb of the proviso was looking for.
My Lord, yes, you summarise it beautifully. There is a line, and this is on the wrong side of it.
Yes.
It's not deceiving. The public is, we know as a fact, they're not being deceived. Which means that the average consumer is taking this to mean there's no milk.
My Lord, no, there I differ from you in that. In that the fact that the public is not being deceived doesn't mean that they clearly understand what is being conveyed to them. It's just they don't clearly understand it to mean that it is milk. So there is one provision says you can only use this designation if it clearly describes a characteristic of the product. The other says one mustn't be deceptive. I paraphrase, but that's the... And there is space between the two.
An undistributed middle.
My Lord, if you will.
I'll have to ask you to wind up your
My Lord,
submissions.
I am at the risk of winding you up, I believe that's where I am.
Well, we all are.
Good, well, I'm less happy. The only final point, I'm not going to address you further on the travaux preparatoire. My learned friend didn't take you to it and didn't go further. Alpro I've addressed you on, but the rest of it, in my submission, those materials really take matters no further on the key before you. If I just check that I'm...
Certainly.
Unless I can assist you further, those are my submissions.
Thank you very much. Mr. Edinburgh, I apologise for describing you after my home city earlier, but I'm pronouncing your name correctly this time.
My Lord, I'm grateful. You're certainly not the first, in my experience, that I've got it wrong. From a very young age, I've been called various things. My Lords, one of the central issues here, I was going to deal with this broadly in 4 different parts. But the first part is this issue with respect to used for, because that seems to be one of the central, most important matters. And the way in which I'm going to deal with this is quite brief, I hope. If you remember Article 5 of the Directive 2000, and it was Article 7 of the regulation to which my learned friend took you, the point about that is that in both of those cases, it is clear that the name is being used for the name of something. Those are the directives that define the term of the name of a foodstuff. And the way in which my learned friend wants to use the phrase used for would widen it such that it's just basically in connection with, which is akin to the whole purpose of the suggested amendment 171 that failed. And in Tofu Town, we say there's support for our understanding of the phrase used for. And he took you to paragraph 40, which may be found behind tab 70 at page 1070. It follows from all of the foregoing that the term milk and the designations reserved exclusively for milk products cannot be lawfully used to designate a purely plant-based product unless that product appears on the list in Annex 1 to Decision 2010. We say that that phraseology, used to designate, clearly is incorporating the concept, the function of naming. So, to reword, reserved exclusively for milk products cannot lawfully be used to name a purely plant-based product. And if you see again in Tofu Town, paragraph, this time 52, which is on the next page, 1071, having regard to all of the foregoing considerations, the answer to the questions referred is that Article 78.2, etc., etc., must be interpreted as precluding the term milk and the designations reserved by that regulation exclusively for milk products from being used to designate a purely plant-based product. And we say that the phraseology used for implies the naming function.
But in tofu, they were being used as names of products.
Yes, but I mean, but it's
cheese.
completely consistent with the way in which they interpret the relevant part of the regulation. It's completely consistent with the fact that the terms designation and sales descriptions are all referenced back to various articles which are using the name of the product. Everything's related back to a naming functionality. It is not wider than that, we say. And that brings me to a point where it was discussed, again with respect to it was Article 17 in the regulation about the food products. And the term where you have to use the name of the food at all points. My learned friend was trying to equate, in essence, the term name with designations. But in my submission, that article really went to the fact that you had to use the correct name of the food at all stages in the food chain. That was fairly clear. Whereas the term designation is the use of the names at all stages of marketing, and the term sales description is at all stages in the actual sale. So they're actually subsets of each other. And in the 2007 regulation, when he was looking and comparing that with the 2013 regulation, and how there was a change in the relevant paragraph 2b between signs and designation, or designations and signs. Sorry, my apology, I got that quote wrong. The change between designations and names to just names, and he said that that was consistent with the fact that the term designations had been deleted. In essence, the definition of the term had been deleted. In my submission, that's entirely consistent with a simplification of the 2013 regulations from the 2007. What they're trying to do is simplify by just using fewer words. And if one term encompasses the other term, then you use the bigger term. We say names is the biggest term, then then designations, and then sales description. A lot of his case hinged on the fact that the term designations was deleted from the 2013 regulation over the 2007 and the 1987 regulation. If the meaning of the term designation changed so much, in my submission, it would have been incumbent upon the legislators to explain that. Otherwise, they're leading everybody into a trap that a word that had been defined for 26 years had suddenly, covertly, changed its meaning. So that's highly improbable. My learned friend took you to part of the beef annex, it's Annex 7, Part 1, as opposed to Part 3 of the 2013 regulation. I think the discussion between my Lord Briggs and Lord Hodge dealt with all that with respect to veal kidneys and beef rump and beef steaks and lamb chops and all of that. So I wasn't going to say anything more on that. There was a very brief point in the Court of Appeal with respect to paragraph 49 of the Court of Appeal, where they talk about collective marks, Jersey, real Jersey milk and things like that. I don't quite understand where that goes, because Jersey milk is being used in relation to milk. And so it wouldn't be a bad designation in any event. You're not using Jersey milk for Brussels sprouts or something like that. So I don't understand where the collective certification marks point goes, because those types of marks are always used with respect to the relevant product. Then that brings me to the trademark point more generally. And it's been put that we have tried to argue that soya to tofu butter is not a designation. Now, the way I argue this is that the three words soya to tofu butter would be understood by the normal person as soya to, which is a registered trademark of a particular company, and tofu butter. And tofu butter is clearly being used in that three-word phrase as a designation of a product. It is being used as the name of a product. And tofu butter is bad. It's prohibited because of Tofu Town, the very case in which the mark appears, because tofu butter has an inherent ambiguity in it. Is it butter made from tofu, or is it butter with a tofu flavour? It's exactly the same point as almond milk. Is it milk from a cow flavoured with almonds, or is it a liquid extract from almond nuts? That's why tofu butter, almond milk, those things are designations because they're being used as a name for a product, and they do not comply with Annex 7, Part 3.5.
And they wouldn't fall within the second limb of the proviso.
Exactly.
And how about veggie cheese?
The same thing.
Because that could be cheese with a vegetable flavour.
Yes.
Yeah.
And then...
Well, yes, that's exactly the point, Lord, you've got it. But then there was also a point that I'm trying to use a trademark as my escape hatch, as my get out of jail card free. And I can use and answer that question by using the example Oatly milk. Now, Oatly is a registered trademark that indicates a trade source. Oatly milk, 2 words, milk is being used as the name for a product. If Oatly milk were used upon packaging containing bovine mammalian extract, that would fall within the permissive use. If it were being used upon a nut extract, liquid extract, that would be bad. So the mere addition of the word Oatly does not save that phrase Oatly milk. I'm not trying to say that the addition of a trademark is my get out of jail card. And similarly, Oatly oat milk would be bad because the phrase oat milk would be has a naming function, so it designates a product, and presumably it's being used in this case upon something that is not a mammalian extract, therefore it's not permitted.
And it wouldn't fall within the proviso either, because it could be milk flavoured with oats.
Yeah.
Right.
Yeah. So this takes me all the way around. I think my Lord Stevens, he said this at one stage, it's all to do with context. And post-milk generation, we say the use of the 4 letters MILK in that phrase would be understood in a certain way, which means that the overall thing, the 3 words, is not being used in a naming function, therefore it's not a designation. That's my primary case. Can I just quickly look? And I think my Lord Burroughs dealt with my last point, which I was going to deal with respect to post-milk generation clearly indicating, because if you're putting it on something, people to whom the trademark is addressed would feel deceived if the thing that has been labelled as post-milk generation contains milk. Therefore, by necessary implication, it doesn't contain milk. My Lords, I have not exceeded my time limit, he says.
Mr. Edenborough, you have not.
I
Are there any further questions from my lords?
I have not a question, but something to say.
Oh.
This, you may or may not appreciate, is Lord Hodge's very last hearing as Deputy President of the Supreme Court and as a full-time justice. He has given long and faithful service to the law and to this court since 2013 as a justice and since 2020 as Deputy President. We, by which I mean his colleagues, some of whom are here, and on whose behalf I hope I speak, have all been constant beneficiaries of his wisdom, his kindness, his calm and good-humoured leadership, and his wonderful clarity of expression. I think we can all think of dicta of his, which it's already perfectly clear will stand the test of time as classic statements of the law. We've had one today, at least one today. He will by no means be disappearing from the legal scene. For example, he will probably take office as Treasurer of Middle Temple in 2027. And even sooner, rumour is that he is soon to become the Chief Justice of the Abu Dhabi Global Markets Court. But for now, whatever he does or does not do in the law, I'm sure that all those present will wish to join with me in wishing him and Lady Hodge a long, happy and fulfilling life in the years to come.
Well, thank you. Thank you very much. I hadn't foreseen this happening, so I have no words prepared, but may I just say it's been a huge privilege to serve in this court for the last 12 and a bit years. And if I have to leave with a message, it is that we should not be despondent about the institutions of this country. I think they are much more robust than our current press and media give them credit for. And while I think it's going to take a lot of energy to overcome issues which this country and most of the West now face, I look to the future, and I hope you do too, with confidence. Thank you all very much.
Thank you.
Thank you, Council, for your submissions. Thank you, those behind Council, for your assistance in the preparation of this case. The court will now adjourn.